Torts can be intentional torts, negligent torts, or strict liability torts. A tort is usually defined as a wrong for which the law will provide remedy, most often in the form of money damages. The law, however, does not remedy all wrongs. The definition of tort does not reveal the underlying principles that divide wrongs in the legal sphere from those in the moral sphere. Hurting someone's feelings may be more devastating than saying something untrue about him behind his back. Yet the law will not provide a remedy for saying something cruel to someone directly, while it may provide a remedy for defaming someone orally or in writing to others. The law of torts developed almost entirely in the common law courts, that is, statutes passed by legislatures were not the source of law that plaintiffs usually relied on. Usually, plaintiffs would rely on the common law or judicial decisions. Through thousands of cases, the courts have fashioned a series of rules that govern the conduct of individuals in their non-contractual dealings with each other. Through contracts, individuals can craft their own rights and responsibilities towards each other. In the absence of contracts, tort law holds individuals legally accountable for the consequences of their actions. Those who suffer losses at the hands of others can be compensated. Many acts, like murder, are both criminal and tortuous, but torts and crimes are different. A crime is an act against the people as a whole. Society punishes the murderer, but it does not usually fully compensate the family of the victim. Tort law, on the other hand, views the death as a private wrong for which damages are owed. In a civil case, the tort victim or his family, not the state, brings the action. The judgment against a defendant in a civil tort suit is usually expressed in monetary terms, not in terms of prison times or fines, and is the legal system's way of trying to make up for the victim's losses. As earlier stated, there are three kinds of torts: intentional torts, negligent torts, and strict liability torts. Intentional torts arise from intentional acts, whereas unintentional torts often result from carelessness. For example, when a surgical team fails to remove a clump from a patient's abdomen when the operation is finished, both intentional torts and negligent torts imply some fault on the part of the defendant. In strict liability torts, however, there may be no fault at all, but tort law will sometimes require a defendant to make up for the victim's losses, even where the defendant was not careless and did not intend to do harm. There is a clear moral basis for recovery through the legal system where the defendant has been careless or negligent or has intentionally caused harm. Using the concepts that we are free and autonomous beings with basic rights, we can see that when others interfere with either our freedom or our autonomy, we will usually react negatively. As the old saying goes, your right to swing your arm ends at the tip of my nose. The law takes this even one step further. Under intentional tort law, if you frighten someone by swinging your arms toward the tip of her nose, you may have committed the tort of assault, even if there is no actual touching. Tort principles can be viewed along different dimensions. One is the fault dimension. Like criminal law, tort law requires a wrongful act by a defendant for the plaintiff to recover. Unlike criminal law, however, there need not be a specific intent. Since tort law focuses on injury to the plaintiff, it is less concerned than criminal law about the reasons for the defendant's actions. An innocent act or a relatively innocent act may still provide the basis for liability. Nevertheless, tort law, except for strict liability, relies on standards of fault or blameworthiness. The most obvious standard is willful conduct. If the defendant or tortfeasor intentionally injures another, there is little argument about tort liability. Thus, all crimes resulting in injury to a person or property are also torts, and the plaintiff may bring a separate or independent civil action to recover damages for injuries to his person, family, or property. Most tort cases do not rely on intentional fault. They are based rather on negligent conduct that in the circumstances is careless or poses unreasonable risks of causing damage. Most automobile accident and medical malpractice suits are examples of negligence suits. The fault dimension is a continuum. At one end is the deliberate desire to do injury. The middle ground is occupied by careless conduct, and at the other end is conduct that most would consider entirely blameless in the moral sense. The defendant may have observed all possible precautions and yet still be held liable. This is called strict liability or liability without fault. This may arise when the defendant engages in ultra-hazardous activities or where defective product creates an unreasonable risk of injury to consumers or others. An example is that incurred by the manufacturer of a defective product that is placed on the market despite all possible precautions including quality control inspection. Tort liability varies by the type of injury caused. The most obvious type is physical harm to the person or property. Physical harm to the person includes assault, battery, infliction of emotional distress, negligent exposure to toxic pollutants, and wrongful death, while damage to property includes trespass, nuisance, arson, and interference with contract. Mental suffering can be redressed if it is a result of physical injury, like shock and depression following an automobile accident. Other protective interests include a person's reputation, privacy, and economic interests. A person's reputation may be injured by defamatory statements or writings. A person's privacy may be injured by those who divulge secrets of his personal life. And economic interest may be injured by misrepresentation to secure an economic advantage or certain forms of unfair competition. We come to the topic of defenses. There are several defenses available in tort cases, but one common rule of exculpation is assumption of risk. Assumption of risk is a defense to a plaintiff's action in tort where the plaintiff has knowingly and voluntarily entered into a risky activity that results in injury. Another defense is negligence of the plaintiff. If two drivers are careless and hit each other on the highway, the court may refuse to permit either to recover from the other. Still another defense is consent. Two boxers in the ring consent to being struck with fists. Therefore, they cannot later on complain that he had been hurt by his opponent. We come to the topic of damages. Since the purpose of tort law is to compensate the victim for harm actually done, damages are usually measured by the extent of the injury. Expressed in money terms, these include replacement of property destroyed, compensation for lost wages, reimbursement for medical expenses, and money that are supposed to approximate the pain that is suffered by the victim. Damages for these injuries are called compensatory damages. They are an award of money damages to make the plaintiff whole as opposed to additional damages that punish the defendant or make an example of defendant. In certain instances, the courts will permit an award of punitive damages. Punitive damages are awarded in cases where the conduct of the defendant is deemed to be so outrageous that justice is only served by adding a penalty over and above compensatory damages. As the word punitive implies, the purpose is to punish the defendant's actions. Because a punitive damage, sometimes called exemplary damages, is at odds with the general purpose of tort law, it is allowed only in aggravated situations. The law in most cases permits recovery of punitive damages only when the defendant has deliberately committed a wrong with malicious intent or has otherwise done something outrageous. Punitive damages are rarely allowed in negligence cases for that reason. But if someone sets out intentionally and maliciously to hurt another person, punitive damages may well be in order. Punitive damages are intended not only to punish the wrongdoer by exacting an additional and sometimes heavy payment, but also to deter others from similar conduct. At this juncture, let us listen to the reporters as they discuss in detail the types of torts, namely intentional torts, negligence torts, and strict liability torts. Thank you.